welcome to Lawishhh, where we unravel the intricacies of the legal system to our views. Today's episode dives really deep into the world of blackmail and extortion laws across Australia, so not just New South Wales. So essentially each state and territory has their own unique legislation, but how do these laws translate into real life courtroom battles? Let's explore landmark cases, legal precedents, and significant influence into the interpretation of these laws across the entire country. So in a very general summary, we need to understand what is blackmail and extortion. Really, in this legal sense, blackmail and extortion are terms that often intertwine, each having their own harbors of distinct nuances that set them apart. So at the core, both involve threats and coercion to unlawfully gain a benefit or cause a loss to another. But how do these acts categorize under Australian law, and what distinguishes one from the other? So before we proceed, have you ever pondered the difference between blackmail and extortion? Share your initial thoughts on the comments. I know it's one of the same people usually think, but under the letter of law, you get very complex and very different elements to the case. So under the legal framework of New South Wales, we'll zoom into where the Crimes Act 1900 essentially outlines this. So the offence of blackmail is under section 249K. So under this statute, sets the stage for understanding the elements that make an unwarranted demand of benefits carrying between 10 years of penalty to 14 years if deemed involved accusing someone of a serious indictable offence. So we've spoken about this before with summary offences and indictable. Go check out my other video about that. But what does this mean in practice? So how does the law define key terms as unwarranted demanded or menaces? You can't just take it on face value. There needs to be meaning behind it, okay? So navigating the nuances of unwanted demands and new menaces require a dive into the statutory interpretation and, of course, case law. So how to courts determine this, what constitutes a proper means of reinforcing demand, or when a threat comes across a line that becomes a menace. There's a lot to it that I have to try to explain in this video, but let's try to dissect these legal terms and explore how these shape the outcomes of blackmail cases. So we talked about this previously, but the penalties in some legal defences, the stakes are high in cases of blackmail and extortion, with penalties reflecting the severity of coercion in another into acting their own will. So, however, the legal system also recognises circumstances where they may mitigate culpability from self-defence to duress to necessity. These defences sort of give a glimpse into the complex realms of criminal responsibility. But what under circumstances can these defences be successfully invoked, and how does the burden of proof shift in these cases? So generally, burden of proof is always on the prosecution, but in some circumstances with defences, sometimes it comes to the defence. So consider a hypothetical scenario where someone is charged with blackmail. What legal defence do you think is the most applicable, and why? Discuss your reading in the comments. I love reading it, and I love to see people's perspective on this very, very crucial issue. But let's go into Queensland. So under extortion with real life cases. So Queensland, a bit similar, but extortion is addressed under what's called section 415 of the Criminal Code 1899, which outlines basically the crime's serious nature, potentially leading to life imprisonment. So one of the pivotal cases that brings the law to life was R v. Black, 2008 QCA 308, where the court examined the elements of demand with intent to gain a benefit or cause a detriment. You see the language, very similar to New South Wales. There's usually a means of gains or a means of loss. That's really it. But in this particular case, we highlight the importance of intent and the nature of the threat, basically proving that it's extortion. Okay, so reflect on how proving intent shapes prosecutions for extortion cases. Then we'll go into the ACT. Again, very similar, but the demands accompanied by these threats go under the legal lens. So the ACT, again, demands these sort of threats under Section 32 of the Crimes Act 1900. This case, which every lawyer would know, is called the Queen v. De La Rosa 2010, ACT CA 3, offers insight how threats to kill or inflict grievously bodily harm are legally threatened, emphasizing the severity and its impact on the victims. This example sort of underscores the ACT's firm stance on protecting one individual from these types of threats. So in Tasmania's approach of blackmail is defined under Section 241 of the Criminal Code, focusing on unwarranted demand with menaces. Again, another case that highlights this is R v. Richardson, 2005 TAS SC 133, which illustrates how the court interprets unwarranted demands and the belief of legitimacy of the menace, providing a detailed understanding of what constitutes blackmail in that particular jurisdiction. So in all essence, how do you think the law differentiates between unwarranted demands and legitimate claims? Well, let's go into Northern Territory, where we examine this very complex issue. So their one, a very similar meaning, but it's under what's called Section 22880 of the Criminal Code, tackles blackmail and extortion by highlighting the demands of which these menaces and without reasonable grounds. Case again would be R. v. Smith, 2014, NTSC 19, which sort of dives into the intentions behind the demand and the use of menaces, offering clarity on the elements needed to prove such a crime.